Get ready for the dictation. Ready? Start. Leave granted. Stop. Para. In the present case, the appellant is the tenant of two shop rooms, one on the ground floor and the other on the first floor, each admeasuring 60 square feet. Stop. The tenant is doing textile business in the room situated on the ground floor, using the first floor as a godown. Stop. The ground floor room was let to the tenant on 10.10.1991 at a monthly rent of rupees 300 dash, which was later enhanced to rupees 800 dash. Stop. The first floor room was let to the tenant on 10.07.1998 at a monthly rent of rupees 250 dash, which was later enhanced to rupees 317 dash. Stop. Para. The respondent landlord filed eviction petitions being RCP number 175 of 2013 as well as RCP number 176 of 2013 on 11.10.2013 in respect of the two room in question. Stop. The said petitions were filed on three grounds, namely, arrears of rent, bona fide requirement for additional accommodation for the landlord's business, and material damage to the premises, under sections 11(2)(b), 11(8) and 11(4)(2), respectively of the Kerala Building Lease and Rent Control Act, 1965. Stop. Para. The trial court in its judgment dated 28.02.2015, held against the landlord on the first and the third ground. Stop. However, so far as the bona fide requirement of additional accommodation was concerned, it was held by the trial court that the landlord is the managing partner of Messrs. Pravish Constructions, and that since the office of this firm was presently only in a small room in the same building, the other two rooms would be required by way of additional accommodation for installing staff members and materials. Stop. The trial court found that the Commissioner's report in the present case did not point out that any particular room was vacant in the premises. Stop. Equally, the production of Exhibit B3, that is the Building Tax Assessment Register, which recorded that some rooms in the ownership of the landlord are vacant, could not be relied upon. Stop. Further, it was held that the tenant had in his possession another room in a neighboring building, albeit leased by his mother-in-law, and stating that since the mother-in-law was not examined by the tenant, the reasonable inference that could be drawn is that the aforesaid room is in possession of the tenant. Stop. Finally, on comparative hardship, the trial court held that the landlord will be able to run his establishment in a better manner, whereas the tenant is not able to establish much hardship caused to him. Stop. In this view of the matter, the eviction petitions were decreed under section 11(8) of the Kerala Rent Control Act. Stop. Para. We have heard learned counsel appearing for the parties. Stop. The learned counsel appearing on behalf of the appellant pointed out that under section 20 of the Kerala Rent Control Act, the High Court, in its revisional jurisdiction, cannot act as if it is a second court of first appeal by setting aside findings of fact by the appellate authority on reappreciation of the same. Stop. He also argued that there being no perversity on the ground, detailed findings given by the appellate authority, the High Court exceeded its revisional jurisdiction in interfering with the same and wrongly substituting the findings of the trial court for those of the appellate authority. Stop. Learned counsel appearing on behalf of the 7 respondent, however, relied strongly upon the trial court's judgment and stated that the appellate authority perversely dealt with material facts on the record and its judgment was, therefore, correctly set aside within the revisional jurisdiction by the High Court. Stop. Over.